calculations to determine the difference between what the defendant would have gotten in a divorce situation versus if her husband died because he was murdered?
I did. That's column F on the far right side. That's delta between, or the difference between a divorce scenario and a death scenario.
Okay. And did you make certain assumptions in this case in these calculations, divorce versus death?
Yes, I did.
And what type of assumptions did you make?
So the first assumption is for the divorce scenario, I assumed that the date of death was also the date of separation.
Okay.
So anything after that date would be separate property of each of the parties. Secondarily, I assumed that for the death, I assumed that Ms. Sementilli would not be found responsible for Mr. Sementilli's death.
So in other words, if she were to be found not guilty, what she would be able to still inherit?
That's correct.
Or if she had not been caught in the first place?
That's
Sustained.
Okay. Did you make any determinations or any assumptions regarding the home?
yes, I did. So on line 6 through 8, you can see that's the amounts related to the house, and the house was sold, and so in the death scenario we have 337,951 at line 9, and in the divorce scenario we have the 218,350, and that relates to it being 50%, because in a divorce scenario Ms. Sementilli would receive half, whereas in the death scenario she receives 100%. However, I didn't include costs of sale here. I didn't assume that the house was sold. I assumed that she would be bought out of the house, and by doing that it actually decreases the amount that is on line 27, the bottom line conclusion, because it increases the amount that would have been in the divorce column. So
if you were, in other words, the assumption is that the house would not be sold in a divorce situation, that the defendant would be bought out, and therefore you're saving closing costs.
that's correct. So it gives Ms. Sementilli more funds in the divorce scenario, so the difference is less, which makes the amount on line 27 to be less. So it's an assumption that is in Ms. Sementilli's favor.
Okay. In other words, making the amount, the difference between divorce versus death, a lesser amount.
Correct.
Did you make other assumptions in the defendant's favor that decreased your conclusion or your bottom line number, which we see, as you said, in line 27 of $1.5 million difference?
Yes.
And what were those?
There were certain amounts that we excluded from the death scenario because we didn't have the source documents to show where they came from. For example, there was 2 amounts that came from Procter & Gamble. One was a distribution. The other was an amount that was held in an account that were noted, one in a trust accounting from Mr. Rubin, one in a filing that we know the funds were received. We know the funds were there, but we couldn't identify the source. And so I excluded those from the calculation, and they would have increased line 27. The third was a computer share account that, again, would have increased the amount, but again, I didn't have the source document to show where it comes from. Those 3 together were approximately $120,000.
You mentioned one of them being P&G distributions. That was per the estate accounting, right? Correct?
That's correct.
Somewhere in the neighborhood of 102,000.
That's right. That was the first one.
A computer share account that was somewhere around $7,700.
Right. It was not a large amount.
Okay. And then P&G stock that was in a Wells Fargo account.
A Wells Fargo investment account.
Okay. And that was somewhere around $12,500.
Correct. So combined, the three were approximately $120,000.
Okay. And all of these were documented in the documentation that you received from the administrators who were appointed by a civil court to handle Fabio Sementilli's estate.
That's correct, but we did not have documentation from Procter & Gamble to identify where they came from or why they were paid. So I couldn't characterize them, and therefore I excluded them from the analysis.
Now, at the time of his death, the victim in this case, Fabio Sementilli, was also receiving various employee benefits that were subject to vesting. What did you do with that?
So for those benefits, to the extent they vest over time, any amount that is earned after date of separation, which again in this case is the same as the date of death, those amounts would have been his separate property. So the longer period we use for the vesting, the more that is separate property.
Okay.
So what we did is assume the shortest possible vesting period. For example, there's one, it's a small amount, it's $4,000, but we assumed that it was 100% vested, so it was all community property. The larger P&G equity award, we assumed only 3 years, so that it was more community property. So again, it was an assumption that was ultimately gave us a conclusion that was more beneficial, gave more funds to Ms. Sementilli in the divorce scenario, thereby reducing the delta and lowering the amount on line 27. There's still a difference, but it is a lower difference than it could have been had we used a more traditional 4 or 5 year vesting period.
Okay. So you made multiple assumptions in order to make the distinction between what the defendant would receive in a divorce versus upon her husband's death due to his murder to her benefit.
Right, but these are assumptions that have to be made when we're doing the analysis because we don't have perfect information. So it's just in order to have an analysis that is the most conservative, we made the assumptions that benefited Ms. Sementilli.
All right. And when we talk about, you mentioned approximately $4,000, the Cody RSUs, that's what we see on line 12, correct?
That's correct.
So you made the assumption that it would all be community property invested at the time of death.
That's correct.
And in terms of the P&G stock options, that's what we see on line 16, correct?
That's correct.
That came to approximately $935,814.
Yes, that's right.
All right. What about Fabio Sementilli's P&G pension? I see that on line 18.
Okay, so again, this is a benefit that upon death vests immediately and still is paid out over a period of time. Ms. Sementilli is given 3 options on how to get it paid out. Each option gives a different amount in total that she could receive. In order to calculate the amount at line 27, I chose the amount that is the lowest possible amount that she would receive. Therefore, the amount that you see at line 18, the 42,682, is, of the three options, the least possible amount that could have been there, which creates the lowest amount that falls to line 27.
Okay. Again, so making the difference between divorce versus death a lower amount.
That's correct.
That was assuming a cash payout.
That's right. It's a lump sum payment.
Okay. Now, were you able to make some determinations, again, from the documentation from the estate on the civil side as to any cash at the date of Fabio Sementilli's death?
Yes, from the bank accounts, we could see that the two accounts, or the total of their personal accounts is on line 2 at $53,563. And the total of the LGI consulting accounts is $9,464. And that totals in column A.
So, for instance, how would that work out in divorce versus death? So we can see how this chart works.
So in column C, you can see, or B and C, in column B, you can see that 50%. And C is 50% of the amounts in column A. Right. And then in column D, you see 100%, and again, 100% of the amount in column A. Because in a divorce situation, it's divide by 2 in California from a community property standpoint.
Cash.
That's correct. And from at the time of his death, there were no designations on the account any other way, and the accounts were joint accounts, except for actually the LGI account was in Miss Sementilli's name. So only. At least from the statements, that's how it appears. So those accounts went 100% to her upon death.
Okay.
And even though the account is only in Ms. Sementilli's name, even in divorce, she would still only receive half of it, because unless she could somehow trace it to, trace the funds that were in there to a separate property source, which I assumed could not be done since LGI was not formed before marriage.
Okay. And so the difference there between what she would get on divorce versus death, we can see that it's a difference of $31,513, basically 50%.
That's correct.
If we had the situation that we do have in front of us where the victim's dead, she gets the full amount of $63,000.
If she's not found responsible.
Yes, that was an assumption we already talked about that you made at the beginning.
That's correct. I can no longer see the line items, but I have a copy in my binder. Is it okay if I look at that one?
Sure, I just wanted to put it on the screen to make sure that where you can see it, I can back out a little bit. There we go. All right, let's talk about the family residence at 5012 Queen Victoria Road. We see that on lines 5 through 8 on your chart. Can you walk us through that?
Yes, so line 5 is just the title. It's just the address. So
Right.
Line 6 is the total amount, and that's the total amount it was sold for. The line 7 is the mortgage at the time of Fabio's death, and then the net cost of sale. So line 9 is the net proceeds, And in fact, I think actually line 7, I could look at my source document, but line 7 is likely the mortgage at the time of the ultimate sale.
Okay. So the home was sold for 1.350. Yes?
Yes,
And they owed a mortgage on the house of 913,300.
that's correct.
Plus there were costs of the sale, as we talked about previously, of 98,750.
749.
Yes. And so how does it work? If there were to be a divorce, this would be characterized as community property?
That's right.
And so therefore each spouse would get 50%.
That's correct. Typically, one spouse buys out the other. It's very common where one spouse stays and then buys out the other, and the other spouse buys a different residence.
And in this particular case, the defendant already received 50%, correct?
That's my understanding of the sales proceeds.
Okay. However, if she were to be found not guilty, then she'll also wind up getting the other half from Fabio's estate. She'll get the full amount, correct?
That's my understanding.
I'm going to object, Your Honor. That's her understanding. No foundation.
So ruled.
So on in death, we're talking about an amount of 337,951.
Correct.
And so the difference between what she would get in divorce versus what she would get if Fabio was dead is approximately 119,600.
That's right.
All right. Now let's look down the column starting on line 10 where it says other assets. Let's look at what you have beneath that. Can you walk us through? The first one we see on line 11 is a 401k that was being managed through Charles Schwab as of December 31st of 2018.
Yes. So that was the, as it says, Cody 401k. And the amount was $30,492. In a divorce situation, Ms. Sementilli would have received 50%. That's the $15,246. Because Mr. Sementilli passed away, she will receive or would receive $30,492. So the difference is the 50%, $15,246.
Okay. And let's look at the next line, line 12. He had some Cody restricted stock units.
That's correct. Same situation. This is the $4,000 that we talked about earlier. It's $3,995. We assumed that they were 100% vested at the time of either divorce or death. And so 50% would be received if in a divorce situation, 100% is received upon death.
For, again, a difference between the divorce versus death of $1,998, approximately $2,000, right?
Correct.
A $2,000 benefit by Fabio dying.
Right.
Okay. And then there was a car loan, and I see here you saw that was written off, so that came to a net total of 0 on both sides.
That's right.
Okay. And then there was accrued vacation that was paid out, which we heard about last week, of an amount of $5,689, which appears on line 14 of your chart.
Yes.
How does that work?
So accrued vacation is not a divisible asset in divorce. It's usually used by the party unless there's some extraordinary circumstance. So an amount of 50 hours would not have been divided. But in the event of death, the company paid it out just like they would if he had left the company. So that $5,689 is the difference.
Okay. So that was, again, a benefit to the defendant by the death of her husband of $5,689.
That's right.
All right. Let's move down to line 15. You have P&G profit sharing, PST.
Yes.
Tell us what we see here, please.
Again, that's a profit sharing plan that had $43,677 in it, and half of it would have gone to Miss Sementilli in a divorce situation, or $21,838, whereas in a death scenario, Miss Sementilli receives $43,677, for the difference being the other 50% of $21,838.
Okay. And again, this was an amount that, just like the vacation, was paid out and transferred to the defendant in March of 2017. So she benefited by almost $22,000 through the death of her husband on this one.
That's correct.
All right. Let's look at the next one, which looks like it's one of the largest numbers, the P&G stock options, which was valued at $935,814. How does that work?
These are the stock options that we talked about a little bit earlier. So part of this is separate property, because after separation, the portion that vests is allocated to Mr. Sementilli in a divorce situation. So we did do that time rule calculation, and $140,102 is carved off completely for Mr. Sementilli. But $795,712 is community property. So 50% of that amount is the $397,856 that Ms. Sementilli would receive in a divorce situation. So it's 50% of the $795. Whereas
Because it's half of the community property portion?
one half of the community property portion. Whereas upon death, she not only receives 100% of the community property portion, she also receives the $140,000 of his separate property.
So in other words, by his death, she winds up getting the full $935,814.
That's correct. So this one is actually the biggest delta. So it's $537,958 that is the benefit for the Procter & Gamble stock options.
Okay. And then also we heard last week about a P&G ISOP, the International Stock Ownership Plan, that we see on line 17.
Yes.
And tell us about those figures based on the documentation you reviewed from the estate.
This one is one where Mr. Sementilli had done a beneficiary designation when he signed up for the program, and he had designated only 40% to go to Ms. Sementilli. So upon his death, that's the portion that she would receive, whereas in a divorce, she would receive 50%. And so this is one where she actually receives more in a divorce situation than she would in a death situation. So it's a negative of $3,988.
Okay.
So.
And then beneath that, you have the P&G pension plan. And you talked earlier on line 18 about there being different choices, whether she took a lump sum or a monthly amount. What was the documentation with respect to his P&G, Fabio's P&G defined benefit plan? Core pension plan.
The core pension plan, we received documentation from the company that outlined a lump sum payment and then two options for payments over time, beginning at different time periods. So beginning in, I could look at the documents if you'd like, but I think beginning in 10 years and beginning in 20 years and going for a certain number of years into the future. And then depending on if you waited the longest period, you actually got it for a longer period of time, or a bigger amount, and so it ends up being a larger dollar figure.
Okay.
But we assumed the one that actually came to the lowest dollar figure, and that's receiving it now, a lump sum cash payment of $42,682. And that is 50% at divorce or 100% upon his death.
Okay. So that's a difference of somewhere around $21,000 to her benefit, using the lower number, the more conservative number, once Fabio died. She gets 100% of it.
That's correct.
All right. And then there's a Wella Canadian pension plan on line 19. Tell us about that.
Yes, that's a very small pension plan, $5,000, and again, 50% if there's a divorce and 100% if Mr. Sementilli dies.
Okay. So the benefit to her, again, is the difference is approximately $2,500.
That's right.
Okay. Then we see that he had 2 accounts through Sun Life Financial, one being a registered retirement savings plan and one being a non-registered. Let's start with the one that's registered on line 20. How does that work?
Again, this is another one that when Mr. Sementilli signed up, he designated the beneficiaries. And so for that one, upon his death, Ms. Sementilli was designated to receive 75% of the funds in that account. So she was to receive $11,700 upon his death, whereas in divorce, she would receive 50%, and that is the $7,800.
This is the one that we talked about earlier, where Fabio had designated 75% to his wife and 25% to his son Luigi, correct?
That's correct.
Okay. So this one is a difference again of $3,900 benefit by his death versus going through a divorce.
That's correct.
All right, let's look at line 20. It looks like line 21, the non-registered retirement savings account through Sun Life. Looks like a very small amount.
Yes, it's a very small amount, $134, and again, it's the 50% versus 100%.
And there was no beneficiary designated, so the full amount would then be payable to the defendant on his death.
That's correct.
All right. So if we look at a total of all of the other assets on line 22, from what is in the estate, $1.135,461,000. 50% of all of that in a divorce would be $499,335.
Just to make sure the record's clear, the first number is $1,135,461.
Yes.
And yes, the portion that is divorce is $499,335.
However, upon his death, the benefit to the defendant is $1,105,895, correct?
Yes.
So when we go over to the difference in the far right column, it benefits her by over $600,000. Is that right?
That's correct. $606,560.
Now let's look at the life insurance proceeds on line 24. Tell us about how this gets handled.
We cannot see that.
Thank you.
The life insurance proceeds are only the life insurance proceeds that are payable to Ms. Sementilli. These don't include the life insurance proceeds that were payable to any other party. And obviously in divorce, none of these are payable to Ms. Sementilli. because these are all term life policies. If they had been whole life policies that had cash surrender value, that would not be the case, but they did not have whole life policies.
So therefore, it's zero on in a divorce scenario, or the full amount on death.
That's correct. And these, I think, primarily related to employment policies.
So in this case, again, we're only looking at the portion of the life insurance that was designated by the victim for his wife. She gets the full 100% of it, which is $720,067.
That's correct.
So the difference is that amount.
That's right, because there's nothing payable upon divorce.
Right. And then on line 25, you have something called post-death separation compensation. What is that?
The company elected to continue to pay Mr. Sementilli for 6 months after he passed, and so that compensation, this is the net that was received after tax, that amounted to $50,271, but in a divorce situation, that would be his separate property. So none of that would be divided with Ms. Sementilli.
So the full, again, just like the life insurance, it's either nothing or the full amount of $50,271.
That's correct.
Okay. And what was the salary amount? Gross?
I would have to look. I have he was receiving, I think, $280,000 is what I was using for other calculations.
Okay. That would be his salary plus some other...
Plus the other compensation.
And again, as you mentioned, this is compensation net, so it's post after taxes are removed, correct?
That's correct.
All right. And then there was also some debt from the credit cards that we see on line 26.
That's right. The parties had credit card debt. So in a dissolution, Ms. Sementilli would have been responsible for half of it. But when Mr. Sementilli passed, she became responsible for all of it.
Okay. So just as in one of the other situations we talked about, I think it was the closing costs on a sale of the property, the entire debt, you subtracted that from the amount that she stood to gain by her husband's death, correct?
That's correct.
From the total that we see over in column F.
Yes, that's correct.
Okay. And so the total difference between, if we look at line 27, the estate being worth $2,262,915 in a divorce situation, she would be looking to inherit approximately $727,000, correct?
She would receive...
Not inherit. She would get, because he hasn't died in a divorce, correct?
That's correct. That's the amount that we could verify.
Okay. And in death, she stands to inherit, assuming she's not found guilty, $2,233,349.
That's correct.
So the difference, again, between what she stands to inherit versus what she would have gotten under a divorce scenario is approximately $1.5 million.
That's correct.
What would happen in a situation, let's say, if the defendant were to remarry in a divorce? What does that do in terms of support?
If she was,
There's no foundation for that, Your Honor.
There is going to be.
I'm all over this.
Would there be some type of support in a divorce scenario?
there would be child support for the 18 months that the one minor child was not 18 or not in high school, and there could possibly be spousal support, very likely at least temporary spousal support.
Okay. And what happens to any type of spousal support if she were to remarry?
It's terminated by law.
Now, were there other amounts that you did not include in your calculations in Exhibit 126?
Well, we've already talked about the $120,000. I didn't account for legal fees or accounting fees related to a divorce. There would at least be legal fees. I didn't account for child support because even though it's paid, it would be paid to Ms. Sementilli, it's for the benefit of the minor child, so I assume that that's where those funds would go. And I did not account for a spousal support amount because it's very speculative, or at least partly speculative, as to how much she would receive.
Okay. Did you see documentation that you received regarding the estate, regarding something called Scissor Boy, or an application that Fabio had created, Scissor Boy?
Yes, and I did not include anything related to that. There was a $25,000 settlement payment that was made to Ms. Sementilli related to that. I didn't include that $25,000 in the analysis because I didn't know if it would have been included in the death scenario, increase the $1.5 million, but I didn't include it because I didn't know if in a divorce scenario there was a community asset that would have been divided. So I just didn't want to include something that could unreasonably change the number upward.
So again, being most conservative and knowing that the defendant got the full $25,000 here, you didn't include it at all. So it's almost like it was a freebie. It wasn't included in your calculations.
Yeah, I assumed it's a wash.
Okay. And when we talked about, when you mentioned spousal support and you said it was speculative, is there a difference between temporary support and permanent support?
There is. Temporary support is the amount that's paid pending the actual dissolution, and it's there's a formula. Child support is always by formula in California. Guideline is what it's called. Temporary spousal support is also by guideline. Typically, it doesn't have to be, but like child support has to be, with few exceptions. Spousal support is typically by guideline as well.
Okay. And in most cases, is it the temporary or the permanent support that tends to be higher, or do they tend to be the same?
Temporary support is almost always higher than permanent support. Permanent support is typically at least 15% lower, sometimes higher. Sometimes it's as much as 30% lower, but it depends on. Permanent support is based on a family code 4320 that outlines 14 different factors that the court considers. So there's much that goes into that that analysis. And so that's where I said it was too speculative for me to figure out what the court would have decided the actual permanent support would be.
Okay. What are some of those factors, those 14 factors that the courts consider for permanent support?
Age of the parties, health of the parties, ability to work, lifestyle of the parties, whether one party contributed to the education of the other party, California's public policy to that people become self-supporting. The very last one is anything else that the court wants to consider. Whether there's been domestic abuse. Those are the ones that come to me.
Okay. Also, maybe the length of the union, the marriage?
Yeah, the length of the marriage is also a factor.
So in this case, we know it was almost 20 years.
That's right. And whether the one party was home, needs to be home with the children.
So if the children are now becoming adults, that would be taken into account that she doesn't need to be home anymore. She could get a job.
Correct. Whether or not the children need someone at home is a factor.
Okay. And what about, you talked about the age of the parties. The defendant in this case, as you know from the documentation, was 44 years old at the time her husband died, so that would also tend to indicate she could earn money.
I understand she was 44, and my experience is that the court would have likely ordered a vocational examination. That would be typical in these types of cases.
Okay. To see what type of job she could do.
That's correct.
All right. And can you give us an estimate of what temporary spousal support would have looked like in a divorce scenario, obviously, in 2017?
Temporary support is based on the guideline formula takes into account child support and is essentially 40% of the payor's gross income less 50% of the person receiving its income. And I did sort of run the calculations to I had to run it to get child support, and the temporary support would be approximately $5,800 a month, and then after tax would be $3,985, or essentially $4,000 a month. And the distinction that has to be made is that this was 2017,
Yeah.
so it was still taxable and deductible at the time. It was prior to the change in the support laws, or change in the tax law. So.
And what about, you mentioned child support that would last for approximately 18 months for the minor child?
The child support was $1,642.
So combined after taxes, what would be the amount for child support and spousal support?
Combined is about
Could I witness let us know what she's looking at this time?
You can do that across.
Thank you.
approximately $5,650.
Per month.
That's correct.
What is that? Did you calculate what that would come to annually?
Approximately $125,000.
Okay. After taxes?
That's correct.
Okay. And can you estimate how long support would have continued beyond temporary support? I know you said that part becomes speculative.
Right. So here's this is why it's not included in my analysis, because I I calculated rough numbers for child support, but this is very much estimates, because all of this is based on an estimated income analysis. So based on just my experience and Ms. Sementilli's age and the fact that she was doing some consulting and that kind of thing, I assumed that she would work, or that she would receive support for another 3 years. So total of 5 years.
Is that typical, 3 to 5 years?
Objection, no foundation.
So rule.
It's not in a marriage of 20 years, but based on her age and just the way things have been over the last 10 years,
Okay.
I would not be surprised if that was.
I'm going to object, would not be surprised, even if it wasn't a question.
That would be irrelevant.
Would that be typical, as I asked?
I'm not objecting, typical.
Given this estate, not a complex estate, this estate.
Given this estate. I'm not sure.
Okay. Would it be unlikely that she would get lifetime support at age 44?
Objection, no foundation.
Speculation sustained.
So if you included what you were talking about in terms of support, child support and spouse support for a period of 3 to 5 years, did you calculate what that amount would approximately come to?
I did.
And what is that amount?
It's approximately $290,000 for the whole
Because-
period.
And you made that estimate based on what you, based on your experience, would be likely in this scenario.
Yes, I did.
Okay. The 3 to 5 year period, not a lifetime support.
Based on 2 years of temporary support and 3 years of permanent support.
Okay. And if you included that number in your analysis, would that reduce the difference between death versus divorce of 1.5 million?
It would.
By how much?
$300,000.
So in that case, we're talking about a difference of 1.2 million.
That's correct.
And you also said that you didn't include approximately $100,000 worth of deposits in your analysis, correct? The $120,000 that she got up front?
Correct. That was part of our speculation bucket, I'll call it.
Okay. So that would, if you had included it, that would increase the amount to greater than 1.5 million, correct?
That's correct.
I have nothing further.
Any cross?
Thank you, Your Honor. Ms. Ebersbacher, in looking at the exhibit 126 that is up there, I don't see any column that addresses the issue of alimony or spousal support or child support that you just discussed in the last half hour or so. Is that right?
Right.
Now, your task, your assignment, if you will, from the district attorney was to calculate the difference financially for Mrs. Sementilli of divorce versus death. Is that right?
Right.
And you agree that one of the primary factors or items in a divorce is alimony.
That's right.
Why is it not included in your chart?
Well, as we just talked about, there are a lot of factors that are speculative when you're talking about the length and amount of alimony. in a dissolution like the Sementillis. And so I calculated it so that Ms. Sementilli could provide the information to the court during my testimony, but I did not include it in this analysis because just like the other amounts that would increase this number, I didn't want to include amounts that were speculative in any component.
Well, but you just gave a figure of $290,000 as being the figure that she would likely have gotten in alimony over the if she had gotten a divorce. Is that right?
And I think I said repeatedly that I think that there are a lot of speculative components to that, but that is my best estimate based on my experience, but it is not. There are a lot of moving parts, and there is speculation in those numbers.
Well, the age of Ms. Sementilli at the time of Mrs. Sementilli at the time of her husband's death was, what was her age?
44.
And what was Fabio Sementilli's age?
I believe he was also 44 or 45.
So I would assume under normal actuaries that they were looking at another 30, 35 years of life, hopefully. Obviously, it didn't occur in this case, but we're talking about divorce. Is that right?
Probably.
And don't you take into account that when you're, how long the wife is going to need alimony to maintain her lifestyle as it was during the marriage?
No.
You don't take that into account in your figure?
No.
So you're saying that in your experience, the amount of time that alimony is paid in a marriage like this would be 3 to 5 years?
Based on all the other factors in this case, yes.
Right. And again, those factors are what?
The fact that Ms. Sementilli was 44 years old in very good health, was a consultant that we only had.
I'm sorry, let me interrupt you. Was it?
Ask that the witness be able to finish her answer.
Okay.
That the income that we were attributing to her was likely understated because we had not done a complete analysis, that it was possible, based on other facts in the case, that Ms. Sementilli would get remarried within some period of time. Those are some of the factors.
Well, the idea of getting remarried in a divorce is present in every divorce. Is that correct?
I would say no.
Okay. Why not?
Many of the divorces that I work on are very long-term marriages, and the parties are not interested in getting remarried.
All right, but we're talking about the ages that you know that the parties were in this case, correct?
Right.
And they've been married for how long?
Just about 20 years.
And does the length of marriage factor into the issue of alimony?
It does.
And how does it?
In California, after 10 years, there's no more presumptive half-life on spousal support.
What does that mean? In layman terms.
It means that if you're married less than 10 years, the court will presumptively, means you will likely get spousal support for half the length of the marriage. So if you're married 8 years, you will receive spousal support for 4 years.
Okay.
If you're married more than 10 years, then you will likely get support for longer than half the length of the marriage.
All right, so if they were married 20 years, half would be 10, so she'd be getting alimony for more than 10 years, correct? Under that formula.
But it's not a formula.
Well, what is it? Is it what the norm has been in California? Is that a way of putting it? What did you just describe on the 10 years or more than 10 years?
Well, it's a presumption, but we also have Gavron warnings that happen in almost every case now. And the younger the person, the more likely that the support is not going to be, certainly it's not going to be lifetime, but the idea that it would even be half the length, I think, is unlikely.
Unlikely. This is all speculation on your part, correct?
Exactly why it's not on that sheet.
Well, but the sheet is designed to document the difference financially between death and divorce, right?
That's correct.
And you're saying basically under a divorce, it's all basically speculative. Isn't that right?
No.
Well, Mr. Sementilli was very successful at his job. You understood that, correct?
I did.
And his salary was increasing, correct?
For the period that we looked at, it was increasing.
And the likelihood would be if he continued working there, it would increase again, correct?
It's possible.
That cost respectively.
Sustain.
If does alimony at all depend on how much money the individual is making at the time?
It depends on how much money both individuals are making.
Well, how much was Mrs. Sementilli making?
The tax returns were reporting approximately, they reported $30,000 the year net the year before, I think 2015, and then $18,000 in 2016.
And that was due to some consulting, correct?
That's correct, but I emphasize reported.
Okay. So, and his reported income was what for the last year before he died?
All in $286,000.
So if you consider that and the length of the marriage, 20 years, isn't there some formula you can use? Since a lot of what you've said is speculation, is there a formula you could use in trying to figure out what the amount of alimony might be per year?
Yes.
What's that formula?
Well, for temporary support, it's the 40% minus 50%. And then for permanent, it's probably 85%. That's the number I use. It's somewhere between 70 and 85%. But for purposes of the $295,000 or $300,000 rounded calculation that I did, it was, I used 85% of the temporary number as the permanent support number.
But the permanent you calculated for 3 to 5 years, is that right?
I calculated it for 3 years to get a total support period of 5 years.
But you understand that alimony remains as long as the parties are alive and the party who's getting the divorce doesn't remarry. Is that right?
Also misstates the testimony.
It's a question. I'm sorry.
You may answer, you know.
That is not my understanding.
All right, so how long does alimony typically last in California?
It varies by facts and circumstances. There is no, I can't possibly answer that.
It can be negotiated, correct?
It can be negotiated.
But if the party who's paying the alimony dies, the alimony stops, is that correct?
Yes.
And if the other party who's receiving the alimony remarries, then the alimony stops, is that correct?
That's correct.
But if those two things don't happen, that is, Ms. Sementilli lives for a normal lifetime and Mrs. Sementilli doesn't remarry, alimony could last 10, 20, 30 years, isn't that right?
In this case,
Well, can you tell us in this case, if they had gotten a divorce and he had continued to, his salary increase and she didn't remarry and he stayed alive, can you tell us how much alimony she'd likely receive over the lifetime of the alimony?
I can only tell you that if it lasted 10 years, I would be shocked.
You'd be shocked if there was 10 years of alimony.
Based on the facts and circumstances of this case, but again, that's my speculation based only on my experience.
And if it lasted 10 years, at the figures you're talking about, what would be the total amount of alimony that she would receive?
There would be the 300,000 plus another 275,000,
So you're talking about $600,000,
600,000 total.
which would be added on your chart to the divorce column versus the death column, correct?
It would be, well, just to make it easy, it'd be 1.5 minus 600. So the benefit of Mr. Sementilli dying versus divorce would only be $900,000.
So if you took $900,000 from the $1,500,000 that you had here as the difference, that would be reduced to about $600,000, correct?
No, you're doing it backwards. I just did the math for you. The
Okay.
$1,500,000 minus the 300 we already calculated, minus another 275,000. So let's just call it 600 to make it easy. That would be 900,000. So the benefit to Miss Sementilli for Mr. Sementilli dying versus the divorce would be approximately, it's $925,000.
Again, based on your calculations involving how much she would receive in alimony.
That's 10 years of alimony.
Okay. And again, none of that, you didn't include any of that in your chart because it was too speculative, is that right?
Well, those are based, well, 10 years is, I would say aggressive, but in Ms. Sementilli's favor. So to the extent it's speculative, it is very much very conservative in terms of what would be helpful to Ms. Sementilli.
Did you talk to, you said you talked to Jason Rubin in this case as part of your investigation?
That's correct.
And remind us who Jason Rubin is?
He is the court-appointed trust accountant or trustee.
And because of the death of Mr. Sementilli and the manner of his death, that he was murdered, there was a court-appointed trustee to handle all of the assets of the estate. Is that correct?
That's my understanding.
Counsel, let me interrupt you.
I need to give the jury and the staff a break, but since we started so late, let's try to limit the break to 10 minutes. The evidence implies, see you back here in 10 minutes.